They're not arguing about a gun. They're arguing about whether a constitutional right still exists. Right now, the Supreme Court is weighing a question that puts millions of Americans in legal limbo. In one state, owning this rifle is ordinary. In another, it's a felony. Lower courts have already called it too militaristic. They've upheld bans. And now that logic is sitting in front of the highest court in the country. Here's the pressure point. If the court stays silent again, judges, not voters, decide what the Second Amendment means. Piece by piece, state by state. Behind closed doors, the justices are deciding whether AR-15s are even arms under the Constitution, whether common use still matters, or whether entire classes of firearms can be banned without a final ruling. One move, one denial, one decision, or refusal to decide could reshape gun law for a generation. So the real question isn't if this reaches the Supreme Court, it's whether the court is finally willing to answer it. The Supreme Court is now weighing a question that could redefine what the Second Amendment actually protects in modern America. The core function and applicability of the Second Amendment stand at a critical juncture as the nation's highest court considers cases that could fundamentally alter the legal definition of protected arms and reshape the boundaries of gun ownership rights across all 50 states. Pushing the boundaries of constitutional law into a new, highly contested era of interpretation. One of the most commonly owned rifles in the country may soon be ruled outside constitutional protection, and the court is actively considering it. The fate of the AR-15 platform, which represents a massive segment of the civilian firearm market and is owned by millions of Americans, hangs in the balance as the justices deliberate whether these specific rifles can be legally classified as arms protected by the U.S. Constitution or deemed so dangerous as to warrant exclusion under state and local authority, triggering a massive legal and political fallout regardless of the decision. This is no longer theoretical. Bans on AR-15s and magazines are now sitting in front of the highest court in the land. After years of incremental court battles and regional legislative efforts, the direct question of whether so-called assault weapon bans and high-capacity magazine prohibitions survive constitutional scrutiny has moved past the lower courts and arrived squarely before the Supreme Court, necessitating a definitive ruling on a deeply polarizing public safety and rights issue. For the first time in years, the Supreme Court is under direct pressure to decide whether millions of Americans are exercising a constitutional right or committing a crime. The ongoing legal conflict creates a perilous gray zone where law-abiding citizens in one state may be in possession of legally protected property, while their counterparts just across a state line could face felony charges for owning the exact same firearm, placing an urgent demand on the court to provide clarity on the legal status of common firearms. Lower courts have already upheld bans on AR-15s, calling them too militaristic. Now, the Supreme Court must decide if that reasoning stands. The application of a militaristic standard by several circuits has been a primary source of conflict, creating a judicial schism where some judges believe the scope of the Second Amendment should exclude weapons derived from military technology, a highly controversial approach that the nation's highest court must now either validate or decisively overturn. A quiet procedural move at the Supreme Court may signal the most consequential Second Amendment decision since Bruin. The seemingly benign process of relisting a petition for conference, where the justices repeatedly discuss and postpone a decision on whether to hear a case, is being monitored intensely by legal observers who recognize this as a potential indicator that the court is seriously grappling with the implications of finally taking on a sweeping rifle ban case. An Illinois county ban is now at the center of a national legal fight that could reshape firearm laws coast to coast. The specific legal challenge, originating from an ordinance in an Illinois jurisdiction, has unexpectedly become the focal point for opponents and proponents of gun control alike, establishing the critical test case that possesses the necessary legal framework to force the Supreme Court to issue a ruling with universal application across the American landscape. The court has avoided rifle bans for years, but that strategy is becoming harder to maintain. For nearly a decade since its last major gun rights decision, the Supreme Court has consistently declined to intervene in disputes over modern sporting rifles. A policy of judicial restraint that has fueled legal uncertainty and court division, and which is now rapidly becoming unsustainable as lower courts issue increasingly contradictory rulings. What happens if the Supreme Court refuses to say whether AR-15s are even protected arms? That question is now unavoidable. A continued refusal to grant review would not resolve the deep constitutional ambiguities surrounding modern rifles. Instead, it would likely exacerbate the growing judicial confusion and solidify a checkerboard of disparate state laws, leaving constitutional rights effectively defined by geographical location rather than national standard. Millions of rifles are legal in some states and criminalized in others, and the Constitution offers no clear answer yet. The massive discrepancy in gun law, where a standard rifle is a common piece of property in Texas, but criminal contraband in New York, underscores a profound lack of constitutional coherence, placing an immense societal burden on the Supreme Court to define the national floor for the Second Amendment right. The justices are facing a growing conflict between lower courts, and the longer it lasts, the more fractured gun law becomes. The existence of a clear circuit split, where federal appeals courts are reaching fundamentally opposite conclusions on the legality of rifle bans, is the precise legal condition the Supreme Court is typically mandated to resolve, forcing their hand to intervene before the patchwork of gun regulation renders the Second Amendment meaningless at a national level. A single Supreme Court decision could instantly affect bans in Illinois, California, Maryland, and beyond. The scope of the decision is enormous, as an affirmation or denial of the constitutional protection for AR-15s would immediately impact similar legislation in numerous states that have relied on the same legal reasoning to enact sweeping prohibitions against specific classes of semi-automatic firearms and their accessories. This case isn't just about rifles. It's about whether courts can redefine constitutional rights by judicial interpretation. At its core, the dispute asks a fundamental question regarding judicial power: whether judges can effectively amend or limit the scope of an enumerated constitutional right based on shifting societal preferences or functional criteria, rather than historical tradition and plain language, setting a precedent far beyond the Second Amendment. For years, lower courts have applied the Second Amendment differently, and now the Supreme Court must confront the consequences. Following the Supreme Court's landmark rulings, federal courts across the country have inconsistently applied the necessary legal tests for gun regulations, leading to a decade of legal instability and conflicting precedents that the High Court is now obligated to reconcile and clarify definitively. A relisted case at the Supreme Court may not sound dramatic, but historically, it's a major warning sign. When the Supreme Court relists a case multiple times instead of issuing an outright denial, it signals internal deliberation and potential debate among the justices, often indicating a deep division or an elevated level of scrutiny that precedes a major institutional decision on whether to accept the case for review. Data shows relisted cases are more likely to be granted review, but repeated relists often means something else entirely. While the initial relisting suggests the case has garnered serious attention, a pattern of continuous relisting, particularly on highly sensitive political issues, can sometimes mean the justices are struggling to form a unified front, or that they are preparing a major statement, perhaps a dissent or a statement respecting a denial, underscoring the gravity of the decision. One justice has already warned that the court can't dodge rifle bans forever, and that moment may be approaching. Clear warnings from certain members of the Supreme Court bench have emphasized that the judiciary must eventually address the constitutionality of widespread rifle bans to prevent further judicial chaos and to provide necessary clarity on the scope of the Second Amendment right in the modern context. If the court stays silent again, firearm policy could be shaped almost entirely by regional judges. Continued inaction by the Supreme Court would effectively delegate immense power to circuit and district judges, allowing localized interpretations and political sentiments to dictate national gun policy, thereby eroding the uniformity of constitutional protections guaranteed across federal jurisdictions. This case asks a blunt question the court has never answered directly. Are AR-15s arms under the Constitution or not? The legal arguments center on a straightforward but profound definitional challenge: whether semi-automatic rifles are classified as arms that are protected for private use under the Second Amendment's historical understanding, or whether they fall outside that umbrella due to design, function, or perceived danger. The outcome here could determine whether entire classes of firearms can be banned without Supreme Court oversight. If the court allows the lower court rulings to stand, it establishes a powerful precedent that permits states and municipalities to use functional criteria to unilaterally prohibit categories of commonly used firearms, effectively bypassing national constitutional review for significant restrictions on gun ownership. A county ordinance, a state ban, and a divided judiciary have collided at the Supreme Court's doorstep. The convergence of local regulatory efforts, statewide legislative action, and entrenched disagreement among federal judges has created the perfect constitutional storm, forcing the Supreme Court to confront the legal and political entanglement that has defined gun policy over the past decade. Behind closed doors, the justices are deciding whether to finally settle the most contested Second Amendment issue of the decade. The intense deliberations currently underway in the Supreme Court's conference room will determine whether the court steps into the political firestorm to resolve the decade-long controversies surrounding modern rifle bans, a decision that carries massive institutional weight and public interest. If review is denied again, the message to lower courts will be unmistakable and deeply consequential. A denial of certiorari would effectively signal the Supreme Court's current acceptance of the diverse and conflicting lower court rulings, potentially greenlighting sweeping bans in states where they have been upheld, and discouraging immediate legal challenges elsewhere, thus locking in the current legal fragmentation. The longer this issue lingers, the more power shifts away from voters and toward unelected judges. When the Supreme Court avoids issuing a clear constitutional standard, the vacuum is filled by federal judges who interpret and apply the law regionally, meaning profound policy decisions concerning citizen rights are being made without accountability to the democratic process, heightening political tension. This case could define whether common use still has meaning under the Second Amendment. Central to the legal debate is the concept of common use, which historically protects firearms widely owned by law-abiding citizens. If the court upholds bans on AR-15s, a weapon owned by millions, it signals a significant narrowing or effective abandonment of this foundational legal principle. A single denial could lock in sweeping rifle bans nationwide without a final constitutional ruling. By simply refusing to hear the appeal, the Supreme Court risks solidifying the conflicting precedents established by the circuit courts, potentially permitting states like Illinois and California to maintain their far-reaching bans without ever facing a definitive ruling on their constitutionality from the highest court. Supporters and critics alike agree on one thing: the uncertainty cannot last much longer. Whether one supports stricter gun control or the expansion of gun rights, there is a consensus that the current state of legal limbo, where the constitutionality of common firearms is ambiguous, is detrimental to both public policy and individual rights, demanding a final resolution from the Supreme Court. What the Supreme Court does, or refuses to do next, could shape gun law for an entire generation. The upcoming procedural decision on whether to grant review of the rifle ban cases carries monumental weight, as it will determine the direction of Second Amendment jurisprudence for decades, defining the types of arms citizens can legally own and the extent of governmental power to regulate them. A promise from a Supreme Court justice is now being put to the test. Previous statements and opinions by several justices, including a clear commitment to address the ambiguities remaining after the Bruen decision, are now facing the ultimate test of implementation as they decide whether to follow through on their judicial philosophy by taking up this profoundly divisive case. The question isn't whether this fight reaches the Supreme Court. The question is whether the court is willing to answer it. While the legal challenges surrounding rifle bans have inevitably arrived at the Supreme Court's docket, the critical institutional decision now is one of judicial courage and necessity. Whether the court will seize the moment to provide constitutional clarity or continue its policy of institutional avoidance on the nation's most volatile rights debate.